you always get those complaints. Well, cops are sitting outside the bar following people home.
Right.
They're completely allowed to do that. It's public. So cops can walk around. They can follow you all day long. Ever wish you could grab a beer and ask a lawyer any question you wanted and have them break it down for you? Law Splaining at GRL Raw breaks down fancified legal mumbo jumbo over beers so all may understand. We're rolling. Welcome to Law Splaining. I am your only person to talk at, Bobby Rehkemper. And today we are going to talk about discarded DNA. So we've talked about it in the past, but what do the Long Island Gilgo Beach serial killer, the Golden State Killer, and Brian Kohlberger all have in common? The answer is simple. It's that law enforcement utilized discarded DNA from the scene or from the accused murderer to connect that individual to the alleged crime. Before we get into the law splaining part of it, DNA for dummies. I'm a dummy. I got this much. This is as far as I go with DNA knowledge. But what is DNA? DNA, simply put, is the hereditary material in humans and almost all other organisms. Nearly every cell in a person's body has the same DNA, and generally speaking, rule of thumb is that DNA is specific to the individual. What happens is that when law enforcement investigates crime, the most common two sources of DNA that are left behind or that are part of the investigation are those that are shed from skin cells through touch or friction, or bodily fluids, blood, saliva, semen, that kind of thing. When there's a touch, a scratch, friction, or excretion of bodily fluids, obviously that leaves cells, which then in turn leaves DNA evidence behind that the CSI guys and gals collect and have analyzed. Just because you have DNA material that's obtained from a scene, though, doesn't mean you can tell who it came from unless you have a known sample to compare it to. When law enforcement gets the DNA sample, they then need to go and compare it to something to see if there's a match. And so what happens is they run it through, there's a number of different databases that they have access to. Sources with known samples include the FBI national database. It's called CODIS. I don't know what CODIS stands for, but it's a mixture of letters that means something more. Iowa also has its own DNA database that we've started here in Iowa, where anybody convicted or that pleads guilty to any type of felony is required to submit a DNA sample, as well as a significant amount of aggravated misdemeanors. The reason behind that is obviously Iowa wants to build their DNA database so that they can see if there are matches. If they run the source, say law enforcement runs the sample through the law enforcement databases and they don't get a hit, they're not out of luck anymore. They used to be they're out of luck. They're not out of luck anymore because more and more there are public open source databases available for DNA due to the growing popularity of services and business like Ancestry.com or the other genealogy type services. That is why you will never see me submit anything to any of these things. I ain't getting caught this way, okay? But if they strike out on all of those, then what do? Okay, they have a DNA cell, where they had the cells, they had the DNA profile, but they have nobody to match it to. They run it through law enforcement, they strike out. They run it through private or public resources, they strike out. Now what do? Well, we watch enough CSI, you've watched enough cop shows, and you know that they start following people trying to pick up things that they throw away. And that brings us to a recent Iowa Supreme Court case of State of Iowa versus Jerry Burns. This case was handed down by the Iowa Supreme Court last year, March of 2023. It's worth a read It's an important case, and I think there's going to be a lot of things that build from this particular case that you're going to want to pay attention to. This case actually dates back to 1979. There was a homicide in 1979 in Cedar Rapids. The victim was a Michelle Martinko. Law enforcement at the time was unable to identify a good suspect in the murder, but they were able to collect a bloodstained dress that obviously contained potential DNA evidence on it. As time progressed, they were dead end. They didn't have anything. But as science progressed, their ability to investigate this case also transformed. Ultimately, they were able to use DNA technology and forensic genealogy, which is fascinating. By the way, at some point in time, we need to get somebody on the podcast to talk about this forensic genealogy because it is bonkers. It's very interesting. But they were able to use those tools to narrow their list of suspects. That's the easiest way to look at it. And ultimately, their list of suspects based upon genealogy and DNA evidence and voluntarily provided familial known DNA samples. So they get like an aunt to give a DNA sample, and they voluntarily do it, and then they're able to limit their suspects even further. So it came down to three brothers, the Burns brothers. And what they started doing is just following the Burns brothers around, seeing if they could identify items that may contain DNA that these dudes discarded. The first was Brother Kenneth. They followed Brother Ken around and were able, for Ken's benefit, they were able to rule him out as a contributor to the crime scene DNA based upon a straw that they picked up from old Brother Ken. They continued to follow Brother Donald, and Brother Donald was ultimately ruled out thanks to a toothbrush that was discarded in his trash. It involved a trash rip. Every episode, something involves a trash rip. But old Donnie was ruled out thanks to that, and that left the final contestant, Brother Jerry. So Brother Jerry, they followed Brother Jerry around, seeing if he would spit his gum out onto the ground, throw out a cigarette butt, and an Iowa classic eating establishment got Brother Jerry. Pizza Ranch. Okay. So Brother Jerry liked Pizza Ranch. He went to Pizza Ranch with his son, sat there and ate the delicious pizza buffet, drank a few soda pops. And then when Brother Jerry left Pizza Ranch, he left his soda cup with the straw on the table. A, pick up after yourself, but whatever. B, law enforcement swooped in, investigators swooped in, boxed up his straw and the soda cup, and sent it away for DNA analysis. The DNA that was on the straw wasn't as strong as they would like, but what happened was they were able to get a close enough connection and they eliminated enough alternatives to be able to then apply for a search warrant to get a good swab, a good sample, known sample from Brother Jerry. Once they got that, they were able to then compare that sample with what they found at the crime scene. And lo and behold, they put Brother Jerry in the vehicle and the crime scene as it relates to the murder. Side note, Brother Jerry couldn't keep his mouth shut in jail too while he was pending trial. And talked too much to fellow inmates, which was not helpful to the Brother Jerry defense. But obviously the attorneys that got the case, they wanted to look at this and they said, ooh, this DNA evidence is bad for us. It had a good defense team. They moved to exclude the DNA evidence obtained from the straw. And they claimed two things. One, Brother Jerry had an expectation of privacy in the discarded straw. Two, even if he didn't have an expectation of privacy in the straw, he did still have an expectation of privacy in the DNA profile that was present on the straw. That was their best argument. That was actually a pretty clever argument. When you look at the expectation of privacy in the straw itself, that's an easy one. That's first year law school. In order for the protections of the Fourth Amendment, so for them to say that you have an expectation of privacy in an object, two things have to be met. One, the individual must seek to preserve that as private. And two, that expectation of privacy held by the individual has to be one that society is prepared to recognize as reasonable. When you look at a straw left in a public restaurant on the table for anyone to access, you lose in point number one right off the bat. There was no attempt to preserve that straw as private. Had he put it in his pocket, had he tied it in a knot, thrown it in the garbage or something, did something to try to protect what was on it, he would have an argument. But when you leave it in a public place on a table for anybody to get, you're losing that. They also said just to be safe, and you don't have an expectation of privacy, especially in something that you discard in a public location. And that's an important thing that distinguishes, for example, trash rips from a private house from somebody throwing away, for example, a cup or a straw in a publicly accessible fast food restaurant. Because you're still leaving that in the hands of somebody else publicly. So the straw was a no-go. The expectation of privacy in DNA contained on the straw was a way more interesting read. DNA profiles are not visible or accessible to the general public. Like I can touch this, I can leave my skin cells behind on this pen, and nobody here is going to be able to, with the technology they have right now, to be able to say, oh, that's Bobby's DNA on that pen. You have to collect it. You have to use specialized scientific methods, send it away for testing, get the results back. So the argument was, hey, even if I didn't have an expectation of privacy in the straw, my DNA on that is still private, and the government shouldn't be able to evaluate it, test it, or get any of the information from it without a warrant or the appropriate probable cause standard that has a suspicious connection, is able to create a suspicious connection to that evidence. The court did make a pretty good point that the majority, the court altogether said, nah, that's not going to work. And they made a good point. This one, I was like, ooh, that's a good argument. Why would DNA profile on a straw be any different than DNA that's, for example, left behind by a rapist? Okay. Or fingerprints left on a burglary, on a window of a burglary, or footprints out in the public. The defense did try to argue that, there's a difference between voluntarily deposited, voluntarily relinquished, i.e. semen in a rape, and that which is involuntarily discarded, for example, skin cells. And they argued that the distinguished fingerprints and footprints, those only tell you limited information. DNA can be taken and evaluated for biology, genealogy, medical conditions. You can get way more information from DNA. So the argument, and I think they're onto something with this, is that to say that you don't have an expectation of privacy in the DNA means that it's open for testing for anything. And if it's open for testing for anything, how far can the government go without violating the Fourth Amendment? The court did put a cautionary note in the majority decision, which is those are some good arguments. In other words, how far can you go with the DNA testing beyond just identifying who deposited it or the profile of the individual? And they said, we're going to save those other concerns that are they didn't say very legitimate. I'm going to say they're very legitimate, and it is a legitimate concern, for another day. But as of this opinion, we're simply saying that the individual profile, in other words, who it's connected to, is not a reasonable expectation of privacy. There were two dissents filed in the case by Justice Oxley and Justice McDermott. And their concern is just that, allowing the government to obtain things like genetic information without the need for a warrant or probable cause. How far can they go? If you say there is no expectation of privacy, then in all reality, you're saying everything is fair game. We can test it for anything and everything that we want. And they weren't willing to go that far, because how cringy would it be, even for private entities, to start collecting discarded straws, discarded cigarette butts, discarded gum, and creating their own DNA profile. Under this decision, there would be nothing that would prevent that from happening. Got a good business idea if anybody wants to partner. But you can learn a lot about people from that information. So, and then it could be made public because there's no expectation of privacy according to the Supreme Court rule. So they were concerned with that. I think they're foreshadowing what's going to happen next. Is there will be times that the government takes that too far, and then we're going to have to come back and reevaluate this whole there is no reasonable expectation of privacy. But to wrap things up on this law splaining, there's a moral behind this story. If you don't want the government to get your DNA, clean your table. Don't throw anything away that has touched your mouth or may have your bodily fluids on it in a public setting. Take it home. Throw it away that way. Burn it. If it's in your personal trash, at least we have the trash pull protections courtesy of Dope Yoda. You can wrangle up the Dope Yoda to put a kibosh to any evidence they get that way. But you're going to see more of this. This is just the start of a whole new area, a whole new arena of fights as it relates to privacy and the government being able to obtain some very, very detailed protected information that otherwise wouldn't be available. So that's all I got for this episode of Law Splaining, Discarded DNA. Appreciate your time, and we're going to be back with the TikTok ban coming up next.